Good morning friends. I am Deepa Khatri, Deputy Director with ICSI. On behalf of ICSI, I extend a very warm welcome to all the viewers at this second session of Capacity Building Initiative of ICSI, the Companies Act 2013, Enable, Evaluate and Excel. The topic for today is related party transactions under the Companies Act 2013 and SEBI LODR Regulations 2015. Related party transactions is one of the significant area under the Companies Act 2013, which calls for greater disclosures and other important compliances. To have a comprehensive understanding of related party transactions, one is required to have a combined reading of the provisions of the Act, the relevant rules, the circulars and notifications issued by MCA from time to time for listed companies in addition to all these SEBI LODR regulations. One should be conversant with the term related party, interested directors, interested shareholders. So to discuss this, we have with us the personality who needs no introduction, Madam Savitri Parekh. She is a senior member of the institute and presently employed as Senior Vice President, Legal Secretarial of Pidilite Industries Limited. Madam Parekh has an industry experience of over 25 years of experience in multiple jurisdictions. She was a government nominee on the Central Council of ICSI. She was associated with an NGO and involved in developing and deploying a module on value-based education for children. She has addressed various seminars, programs conducted by IIM Kolkata and expert contributor to Ramaiya, Bhandari, etc. And she is a member of Sector Standards Board of ICSI. We also have with us Mr. Vibrant and active council member of ICSI, who is a chairman of PMQ course committee. I would now request Mr. Ranjit Pandey, council member of institute, to take over.
Good morning friends, welcome you once again to the second technical session on the Companies Act, Enable, Evaluate and Excel. So this series is a welcome series and definitely we have got a tremendous response in the introductory session wherein we have discussed the overview of the Companies Act, and also we have taken up the profession related issues, how the company secretary should take up the Companies Act at strategic level and how we should use the Companies Act in the board functioning and to improve the corporate governance of the company. So friends, in that series only, taking it forward, today we have decided to have session on related party transaction. I know each and every company secretary, whether in practice or in employment, they face on day-to-day basis related party transaction issues, whether certain transactions are at arm's length or not, whether it is ordinary course of business or not, who are related party, what is related party transaction, whether it should be as per AS 18 or 8 transactions specified in 188, 2 subsection 76. So many questions are there, so many doubts are there, and I can witness that already 800, 900 approximately people have logged in, and even before starting the session, and I have already having 20-25 questions. So friends, definitely we will take up all the questions raised by you. Kindly be brief in your questions and to the point in asking the questions. Savitri madam is expert faculty in this particular topic. She has written a book on this particular topic. So who better than Madam Parekh to deliver lecture or address the concern of the members on this particular topic. So I request Madam Parekh to start the session, and she will be taking up the brief provisions initially. That does not mean that you will not be able to ask question in between. You can ask the question in between also, and we will take note of I am noting all the questions. Questions are already here, so we will take up the questions. I will ask in between, and she will be interacting with you in the question answer form also. Over to Madam Parekh.
Very good morning to all of you. It's indeed my pleasure and privilege to be addressing this first technical session. I do know that you had an introductory session earlier, and this is the first technical session on this excellent program on Enable, Evaluate and Excel. Many thanks to Deepa as well as to Ranjit Pandey. my colleague on the Secretarial Standards Board. He was there in the 16-17 Secretarial Standards Board with me, and we've done excellent work together, and I'm therefore very happy to be addressing this session. The topic of related party transactions is a very important compliance issue relevant to all the company secretaries, and I'm indeed very happy that this is the first topic that we are covering today in this program on Enable, Evaluate and Excel. The overview of what I propose to cover in this session, and therefore I would invite questions even as I go along. I would like to cover as to what is a related party transaction, who is a related party, provisions of Companies Act in particular with respect to section 177, 188 and of course read with rule 15.2 and 15.3 and secretarial standards wherever they become relevant from a compliance perspective. Of course, apart from this, there are other relevant provisions like provisions with respect to quorum under section 174, in particular the explanation under section 174.3, 184.2 which deals with disclosure, the amendment bill of 2016 which is yet to be passed, but at the same time the changes that are proposed in the amendment bill, and LODR provisions with respect to related party transactions, in particular regulation 23, as well as provisions with respect to disclosure in the corporate governance report which is required to be given in the annual report. Of course, I would also like to touch upon the disclosure provisions under the provisions of Companies Act. Feel free to ask questions as I go along, and I would be happy to answer them. I only have one request. If there are specific questions where you refer to a case which I need to understand, in the sense that if it is A Limited which is interacting with somebody and so on, if the question is a little long, please ensure your question is elaborately written so that there is nothing which is missed out. Moving over to the provisions of Companies Act, the term related party is defined in section 2 subsection 76 of the Companies Act 2013. We also have reference of the term interested director which is defined in section 2 subsection 49 of the Companies Act 2013. The term interested director, however, is proposed to be dropped as per the provisions of Companies Amendment Bill 2016. If you refer to the term interested director, although it is proposed to be dropped, I would like to spend a minute on this particular definition. The term interested director, as is referred to in section 2 subsection 49 of the Companies Act 2013, is very similar to what was referred to in section 300 of the Companies Act 1956, where it referred to interest which was either direct or indirect. But Companies Act 2013, wherever there is a reference to interested director, has made specific reference to section 184 subsection 2. So, in order to understand the provisions of related party and approval matrix as is provided under Companies Act, the starting point would be section 2 subsection 76 to see as to who is a related party, and also with respect to disclosure which is covered under section 184 subsection 2 and 177 and 188. Let me move over to the broad issue with respect to schedule of authority provided under Companies Act. At the base level, you have approval by the audit committee, where a company is required to have an audit committee under section 177 of the Companies Act 2013. As per section 177 4 subclause 4, it is necessary to seek approval of the audit committee to all related party transactions. If the transaction is one which is covered under section 188, it will get covered under 188 only if it is not in the ordinary course of business or not an arm's length basis. Then approval of the board or shareholders, as the case may be, would be required. That's the broad schedule of authority. Of course, I would go into a little more details as we proceed with the session. So, it is necessary to understand the schedule of authority. In every case with respect to a related party, approval of the audit committee is required to be obtained if the company is required to have an audit committee and has an audit committee, and approval of the board is required only if the transaction is one which is covered under section 188. Also, you would require approval of the shareholders if, as per section 188, approval of the shareholders is required to be obtained. So, the authorities who are given the authority, given the powers to approve a related party transaction are the audit committee, board and shareholders. Of course, it is not necessary that every transaction moves through all three. In few cases, it might just require audit committee's approval, or rather, if it is a company which has an audit committee, all cases will necessarily need approval of the audit committee. Few cases will need to go to the board and fewer cases will need to go to the shareholders. That's the broad structure with respect to authority. If you look at the provisions of section 2 subsection 76, who is a related party? Why do we have provisions of related party transactions in the Companies Act? The main provision is because there is a conflict of interest. You would observe that under section 166 of the Companies Act 2013, which deals with duties of the directors, there is a provision which says that a director shall not appropriate or have conflict of interest or appropriate any opportunity which otherwise should belong to the company. In line with this provision, you have provisions dealing with related party transactions, and the law provides for a framework for approval of related party transactions. Hence, we now move over to the basic provision of who is a related party. Section 2 subsection 76 of the Companies Act, as I mentioned a little while ago, defines the term related party. Now, a director would be considered as a related party. So, therefore, if there is a dealing between the company on one hand and a director or any of the relatives of the director, it would be considered as a related party transaction, or a firm in which the director is a partner, or a private company in which the director is a director or a member, or a private company in which the director's relatives are directors, or a public company, note this particular point, or a public company where the director is a director and along with his relatives, along with his relatives holds more than 2% of the share capital of the company. This particular point is very important, and I will come back to this in a minute. And it goes on, and the other point with respect to related party is that under section 2 subsection 76 subclause 8, it says a company which is a subsidiary or a holding company or an associate company of such company. This particular provision, subclause 8, is proposed to be amended under the Companies Amendment Act of 2016 because there is a small mischief which has crept in, where it refers to a company which is a subsidiary or a holding company or an associate. The term company is defined under section 2 subsection 19 of the Companies Act, section 2 subsection 20 of the Companies Act 2013 as a company which is registered under the provisions of Companies Act 2013 or under any of the earlier Companies Act, which is 1956, 1913 or so on. Which actually means only if it is an entity which is registered in India can it be covered as a holding company or as a subsidiary company or as an associate company. If you refer to the term subsidiary as is defined in section 2 subsection 87 of the Companies Act 2013, the term subsidiary can also include a body corporate which is incorporated outside India. But going by section 2 subsection 76 subclause 8, it is restricted only to a subsidiary which is incorporated in India, and hence this mischief is proposed to be removed by the Amendment Bill 2016 so as to cover a body corporate which is a subsidiary or an associate company or a holding company of such company. So, broadly those are the categories of persons, and of course the term related party also includes a key managerial personnel or a relative of the key managerial personnel. Now, if you refer to the term key managerial personnel, the other persons who are not covered in directors are the CFO, company secretary, manager and a CEO, because a chief executive officer need not be on the board. Similarly, a manager need not be on the board, although section 196 will have to be complied with respect to appointment of a manager. A CS and a CFO also would be key managerial personnel, and hence the term KMP has also been included. That merely covers definition of the persons who would be covered. So, if there is a transaction between the company on the one hand and any of the related parties, it would then be said to be a related party transaction. This particular point is also worth noting because it might well so happen that it may be a transaction which does not involve the company and the related party, in which case it will not be a related party transaction requiring approval under 177 or 188 of Companies Act 2013. Ranjit, do you have any question for me to?
I think initial level one question is coming time and again.
Sure.
Whether salary to company secretaries, KMPs are covered in the office and place of profit. If yes, then as per the limit specified in the rule, salary is generally higher than do we need to take members' approval. Similar question is that if listed company is inviting, say, paying remuneration to directors and KMP, and it is subject to, say, their term of employment, so whether it will be considered as place of profit. So I think place of profit
Sure.
should be explained a bit.
Okay, yeah, I'll come to place of profit in a little while once we go to section 188, but I think these two questions are really good. Coming back to section 2 subsection 76, one point which I had marked a little earlier is the one with respect to 2% of the paid up capital of the other company. Section 2 subsection 76 refers to holding of 2% by the director along with his or her relatives, while if you refer to section 184 subsection 2, it refers to holding by the director along with other directors on the board of the company. I would say from a conservative perspective, to err on the side of caution is always advantageous. So please take into account the director's holding along with his relatives and the holding of the other directors, so as to see whether it falls, it goes beyond 2% of the paid up capital of the other company. Of course, it would be an over compliance on this point, but from a governance perspective, I certainly would recommend it. Going by section 184, it's only the directors holding along with other directors holding.
Another related question, salary paid to relative of directors in ordinary course of business is ordinary course of business and in respect of his post in the company, whether this transaction required to disclose as related party transaction in the annual report, because they are saying that relative to payment to the relative of director is in ordinary course of business. He is employee of the company, although he is relative but employee of the company, so it is ordinary course of business. So if it is ordinary course of business, why it is required to be disclosed in the annual report?
That's a very, very good point. What we need to understand is approval and disclosure are two essential elements which one needs to take into account when you consider corporate governance provisions. Approval is of course of a slightly higher order, but when you refer to disclosure, disclosure is done so as to show that what you're doing is in accordance with the provisions of law. So therefore the law may mandate a disclosure. Transactions with a related party where the company is dealing with a related party requires disclosure. For example, if a relative of a director is holding a position in the company, let's assume two separate situations. One, where the relative is appointed after the person becomes a director on the board of the company. Let's check whether on the touchstone of section 2 subsection 76, this transaction becomes one which would fall under related party transaction. Of course, it would fall under related party transaction because relative of a director is certainly a related party. So therefore, if assuming it's a company which has an audit committee, the audit committee has to approve it, because all related party transactions require approval of the audit committee, and you would then need to see whether it requires approval under section 188. While it may be in the ordinary course of business, since the provision very clearly states appointment of a person to an office or place of profit, this particular provision will need to be tested under section 188 subsection 1F. Now, it says, except with the consent of the board of directors given by a resolution of the board passed at a meeting of the board, the company shall not enter into any contract or arrangement with a related party. Is this person, the relative of a director, is a related party? Answer is yes. Now, the subclause F says such related parties' appointment to any office or place of profit in the company, its subsidiary or associate company, is at a remuneration exceeding 250,000 rupees per month. Now, remuneration is also a defined term. Isn't it defined under section 2 subsection 79 of the Companies Act 2013?
It is defined.
So, if and remuneration is a term which covers all amounts paid by the company. I'm sorry, it's 2 subsection 78. Remuneration means any money or its equivalent given or passed to any person for services rendered by him and includes perquisites as defined under the Income Tax Act. So, appointment of a relative of a director would certainly be covered under section 188 1G of Companies Act 2013. If the remuneration exceeds 250,000 per month, and if the person is proposed to be appointed either in the company or in its subsidiary or associate company, you will require approval of the shareholders to be passed at a general meeting. And of course, in this particular case, going by the provisions of Companies Act and going by the second proviso to section 188(1), the related parties will not be entitled to vote. Related party for the purpose of Companies Act, for the purpose of section 188, would mean the director who is a related party to that particular transaction and members who are related parties to that particular transaction and not others. However, if the company is a listed company, going by regulation 23 of LODR, Listing Obligations and Disclosure Requirement Regulations 2015, related party is a set term, and regulation 23 states that all related parties will not be entitled to vote on a transaction irrespective of whether the person is a related party in that transaction or not. Of course, what is covered under LODR is slightly different. What is covered under LODR is only material related party transactions and not other transactions. So, coming back to the specific question of appointment of a relative of a director to an office or place of profit, where the person is going to carry a remuneration, where the person is going to get a remuneration exceeding 250,000 per month, this would require approval of the audit committee, the board, as well as of the shareholders, where the related parties to that particular transaction, the directors and other members who are related parties to that transaction, will not be entitled to vote. I presume this would not be a material related party transaction, because one has to look at the capital of the company, the net worth of the company, as well as the turnover of the company at a consolidated level for determining. And for the purpose of salary, it definitely cannot exceed the threshold of 10% of the turnover of the company or of the net worth, and hence I would say it will not be a material related party transaction. Yeah.
One primary question, I think this question need to be addressed on regard to applicability. Section 188 is not applicable on private company. Does it mean that a private company need not disclose the same in AOC2? I think this clarity is required to be given that it is applicable to the private companies as well.
I would actually like to draw your attention to the notification of 5th of June 2015, which grants exemptions to private companies, and section 184 subsection 2, which deals with disclosure and the thresholds which are given over there. The notification states that section 184 will be applicable to a private company, except that a director of a private company who is interested in a related party transaction will have to make a disclosure, but he will be entitled to vote. That does not mean that
Participate.
does not mean that 184 is exempted. Let me repeat, going by the notification of 5th of June 2015, section 184 is certainly applicable to a private company. The exemption or the relaxation which has been given is that the director can make a disclosure, should make a disclosure, and after he has made a disclosure, he would be entitled to participate in the discussion as well as in the voting. This once again can be compared with section 300 of the Companies Act 1956, which said that in case of a private company, an interested director can participate and vote, which is exactly what 2013 has brought in. Moving over to section 188, nowhere is there an exemption with respect to 188 with respect to private companies.
Add OPC also, because OPC question, applicability question has also
Of course,
been. OPC is a private
company.
of course.
Yeah, absolutely. It's a private limited company, and therefore the provisions will be equally the same. I must also draw your attention to section 167(1)(c) and D, which deals with vacation of the office of directors if there is no disclosure made by the director, or if a director participates in a related party transaction where he is interested, he would actually be deemed to have vacated his office. And of course, going by provisions of section 184, there is a further penal provision which also includes imprisonment. And as you know, under section 441 of the Companies Act 2013, wherever there is an imprisonment and fine, or imprisonment or fine, permission of the special court will be required for compounding. It is not one which can be directly compounded. Although the fine may be less than 5 lakhs in certain cases, it will be necessary to go to the special court if there is a penalty in the form of imprisonment and fine, or imprisonment or fine. Ranjit, does that answer the question that you had raised? Yeah. Okay. So shall we move on further? As I was just mentioning, the last point that I was covering with respect to section 2 subsection 76 was the 2%, where I said that while section 2 subsection 76 refers to 2% along with other relatives of the director, under section 184(2) the reference is 2% along with other directors of the company. 177 provides for approval to be granted by the audit committee, and an omnibus approval can also be granted by the audit committee. Of course, there are certain conditions which need to be complied with, and based on that the audit committee can grant an omnibus approval. This omnibus approval provision is very similar to what is covered under listing obligation and disclosure requirements, LODR. I'll go on with other provisions of LODR little later. Section 188 is the provision which has 2 parameters. In fact, if you refer to the structure, as I was mentioning, one is the schedule of authority, which I explained, audit committee, board and shareholders. If you refer to the broad provisions under Companies Act, the main provision which is covered with respect to related parties is the touchstone of ordinary course of business and on arm's length basis, or a transaction which is not in the ordinary course of business, or which is not in the not on arm's length basis. If you compare this with this model of ordinary course of business with what is provided under LODR, LODR has a very simple test of material related party transactions or transactions which are not material related party transactions. This distinction is very important to understand. And more importantly, if you refer to the secretarial standards, if I remember the para right, it is 7.5.2, is that right, Ranjit? Which deals with, yeah, that's right, which deals with a member who is a related party in a transaction who cannot participate in the voting and in the discussion on that particular point. Now, very often there are questions which are raised that in case of a listed company, a combined reading of section 188 read with regulation 23 read with para 7.5.2 of secretarial standards 2 leads to a confused situation where one is not clear as to whether the chairman of the board can preside over the meeting of the shareholders or not. I would actually like to clarify this right away, that if the transaction is one which is in the ordinary course of business and on arm's length basis, section 188 is not applicable at all to such a transaction. And if it is one which is purely falling under regulation 23 of LODR, because it is a material related party transaction, para 7.5.2 will not have a bar on this at all. Also because the member does not have direct interest. And this particular question becomes very relevant if it's a transaction between the holding company and its subsidiary. If it's a wholly owned subsidiary, there is no problem, because regulation 23 is very clear. The transactions between the holding company and the wholly owned subsidiary will be completely outside the provisions of LODR. But if it's a transaction between the holding company and a subsidiary which is not a wholly owned subsidiary, one needs to see whether it's a material related party transaction. If it's a material related party transaction, 188 will not be attracted if it is in the ordinary course of business and on arm's length basis, and in which case there is no bar under 7.5.2 for the chairman of the board to preside over the meeting as well as consider this particular item of business and transact the same.
2-3 questions on arm's length and ordinary course of business itself, because since we are discussing this,
Sure.
so we should take up this question. First, meaning of the ordinary course of business should be explained.
Right.
Second, how to determine the related party transaction at arm's length transaction if
Right.
no such transaction with unrelated party.
Right.
So first question is ordinary course of business, kindly elaborate.
Right.
And arm's length, how to determine the arm's length transaction.
Right.
Third question is, if transaction is ordinary course or arm's length basis, then disclosure is required to be given in the director's report, more specifically in AOC 2.
Sure. Well, the term ordinary course of business is not defined in the Companies Act 2013. But is it required to be defined? Because what is in the ordinary course of business is something which the company needs to do while it is carrying on business in the ordinary course. Say for example, if there is a company which is into manufacturing, purchase and sale of goods, taking premises on lease, rent, construction of factory, employment of people, etc., will all be considered as ordinary course of business. I would say that the term ordinary course of business is one which goes on with the concept of going concern of the business. So as to be able to carry on the business, several activities are carried on by the company, and all these will automatically get covered in ordinary course of business. But let us assume a transaction which would not fall under the head of ordinary course of business. Let's say for example, a company which is into manufacturing decides to let's say acquire another company which is completely in an unrelated business. It may be for diversification, but is that considered to be in the ordinary course of business? Probably no. So therefore, one would need to see whether this is in the ordinary course of business or not. And such transactions would therefore require approval of the board and shareholders depending on the threshold that we are looking at. Arm's length basis, once again, the term arm's length basis has been explained in the explanation given under section 188(1), where there are two specific clauses under which it says as to whether a transaction would be considered as arm's length basis or not. Say for example, if it's with respect to remuneration of a director, then will it be considered as an arm's length basis if the director gets a remuneration which is in accordance with the provisions of Schedule 5 read with section 197, where he gets what he is entitled to get under the provisions of Companies Act. It would be considered as ordinary course of business and on arm's length basis. It will not be considered as an office or place of profit, is what is clarified. And arm's length basis is not specifically defined as to what would constitute arm's length basis. Does arm's length basis mean arm's length price, or does it mean something more than that? I would say that price is just one of the components of terms of dealing, and there are several other points which need to be taken into account. Let me give an example. Let's say you are dealing in trading of goods, and ordinarily the price charged by you to unrelated parties is, let's say, 100 rupees per unit, and you deal with a related party and you sell the goods at, let's say, 101 rupee per unit. Is this considered as arm's length? Well, on the face of it, if you just compare price to price, it may be arm's length. Now, let me add in some more complication there. For 100 rupees, your credit period is 15 days. The party is required to pay off in 15 days, while with respect to this related party, you give 6 months. Let's look at, and if there are such other additional points, the entire bundle of terms and conditions need to be considered, not just price. So arm's length basis does not mean arm's length price in isolation, but everything else being equal, arm's length price,
Transaction as a whole.
yes, the transaction as a whole has to be taken into account, and everything else being equal, price becomes a quantifiable parameter, and hence it would be taken as one of the important factors there. But you also need to see the other parameters to see whether it's a transaction which is on arm's length basis or not. And typically with respect to remuneration, since there is this particular doubt, is the reason the Act very clearly covers and defines the term office or place of profit, and arm's length basis is not clearly defined, ordinary course of business is not clearly defined, but that's exactly where one can use a reasonable basis to arrive at a judgment. It's quite common to use the transaction pricing methodology which is given in the Income Tax Act transfer pricing guidelines for the purpose of determining whether the price is on arm's length or not. As I said a little while ago, if everything else is equal, price becomes a parameter which is quantified clearly and therefore easy to use as a parameter for comparison. So even if you are dealing with only one party and you do not have a comparable unrelated price, if it meets any of the 6 tests which are given in transfer pricing guidelines, I would say that will also be good enough, and it can be used as a parameter to justify and say that it's an arm's length basis transaction.
I think there are a lot of confusion in disclosure in regard to AOC2.
Right.
So there are 4 questions on AOC2. I'll deal with them combined.
Sure.
Do we require to mention in AOC2 regarding items which are falling in the ambit of third proviso of 182, that is dealing with the arm's length and ordinary course of business again?
Right.
So whether if a transaction in arm's length and ordinary course of business, whether it is required to be disclosed in AOC2, that is question number 1.
Right.
Second is RPT disclosure in AOC2 and balance sheet note AS18 in the annual report. Part A of LODR, Part A, Schedule 5 of LODR, a separate requirement.
Right.
Is there any transaction which is not covered in AOC2 and AS18? Schedule 5 will cover it. So that is second question. Third question is related party transaction mentioned in auditor's report and AOC2 are same, again related question. And what transaction required to be disclosed in AOC2?
Okay, fine. Let us start with AOC2. I would not claim to know the form by heart, so it will be helpful if I get to see the form. But I can tell you offhand, AOC2 uses the term material related party transactions. Now, any transaction with a related party which is material, Section 188 does not use any reference to materiality per se. So, going purely by form AOC2, a transaction which is in the ordinary course of business and on arm's length basis but is considered to be material will require disclosure in my view. It does not require any approvals if it's in the ordinary course, because approval matrix, as I said, is basically 177, 188. You may not require any approval at all, but you still require a disclosure. It's more from a transparency perspective that disclosure is required. That's on AOC2 broadly. If you refer to LODR, LODR clearly refers to the term material related party transactions, where there's a threshold which is given of 10% of consolidated turnover or 10% of consolidated turnover of the entity concerned during the financial year, then you require approval of the shareholders. Now, if it breaches this particular threshold of 10% of turnover of the listed entity concerned and you require approval, then you're going to be taking approval. But AOC2 is not dependent on this particular material related party transaction under LODR. So, the two are completely on two different footings there. AOC2 has two separate heads. One is with respect to material related party transactions, second is with respect to 188. So, any transaction which is not in the ordinary course of business or not an arm's length will require a separate disclosure, and one which is material, although it may be in the ordinary course of business, will require disclosure. What is material under Companies Act 2013 is not specifically a defined term. So, therefore, it is left to the company, left to the board to take a judgment on this. I would say that if it's a listed company, maybe one would look at 10% threshold, because in any case you would have taken approval, so it's quite okay to be covering it here. If it's an unlisted company, then it is up to the company to see, but maybe 10% would be a reasonable estimate to take. 10% could be used as a threshold. However, that's personally my view. It's left to each individual company, I would hasten to add. Does it address all the main questions?
AOC4,
Yeah.
AOC2.
So AOC2 has been addressed. The other question that was asked, a very interesting question as to whether LODR, AS18 and AOC2, is there anything which is in addition? Let me tell you that the AS18 requirements are applicable with respect to the accounts and schedule to accounts, where the auditors have to see whether the accounts are in accordance with accounting standards, and AS18 is nothing but a clear disclosure which specifies as to the transactions during the year with related parties. So the auditors would have a list of related parties to be disclosed in the accounts of the company, in the notes to accounts of the company, as well as the transactions which have been entered into. AS18 also refers to specific points which need to be covered over there, and it has to be a commercial transaction. You would need to cover under LODR related party transactions which are covered under Part A of Schedule 5, where there are 3 separate disclosures which are covered to be given, and 2 of which are to be disclosed in the annual report of the holding company, and 1 is required to be disclosed in the annual report of the subsidiary company. And basically it deals with loans, loans which have been granted, or advances which have been made, anything which is in the nature of loans, and this has to be disclosed with respect to whatever has been given to the subsidiary or the associate companies, and also with respect to entities. The third provision, which once again deals with loans and advances, it also says that where the company has given a loan to a company, the loanee company's investment in the subsidiary or in the associate company is also required to be disclosed. So this is a very important provision. And the other one is with respect to subsidiary, where any loans have been granted, the subsidiary is also required to make a disclosure. This provision of such a disclosure finds a mention in LODR. Of course, even under accounts, there is a reference to loans which have been granted, which is required to be stated in the accounts. But this specific disclosure of further investment by the loanee in the subsidiary or in the associate company, if I remember right, is only under LODR. It is not specifically there in the accounting standards, to the best of my knowledge. As per LODR, you are also required to make a disclosure with respect to the policy on material related party transactions, and a web link is required to be given with respect to material related party transactions, policy on related party transactions, which is required to be given in the annual report, which does not find a mention in AS18.
I think some confusion is there.
Right.
So many times people are asking question on this particular point. 5th June notification,
sure,
giving exemption to private limited company. So although you have answered this particular question, but I want to repeat those questions for the benefit of all the members. One of the question is, in case of private company, a director can participate in the meeting as exemption is given to private company under section 184. However, no corresponding exemption is given to private company relating to quorum. Can it be assumed that an exemption is given under section 184(2) is also exemption to private company regarding quorum under section 174, and hence the interested director presence can be considered for the quorum? That is one. Second is also related, whether this participation includes voting or not. So these are the 2 questions. Other questions are also there, but these if you will answer this question, other questions will be addressed.
Talking of quorum, if I remember the section right, it's section 174 subsection 3, and the explanation given under section 174 subsection 3 very clearly states that for the purpose of quorum, interest of director shall be reckoned in accordance with the provisions of section 184(2). Hence, an exemption under section 184(2) would automatically travel back to section 174(3) explanation given thereunder, and therefore a director of a private company who is interested in a transaction and where the private company's director has made a disclosure of his interest will be entitled to participate in this particular item of business, and in particular he would be counted for the purpose of quorum because the explanation to section 174(3) links it to 184(2), which has been clearly relaxed in case of a private company. So therefore he would be counted for quorum, he or she would be counted for quorum. Entitlement to participate at a meeting includes the right to participate in the discussions as well as vote at the meeting, and therefore he would be entitled. In case of a private company, a director who is interested in an item of business would be entitled to participate in the discussions as well as vote on that particular item of business.
Whether any transaction between holding company and subsidiary company exempt in all cases, whether approval of shareholder required when amount exceed the limit prescribed under 188. So again, I think relating to 5th
Sure.
June notification only.
Yeah. Can you just repeat the question once again?
Whether any transaction between holding company
Yeah.
and subsidiary companies
Just pause
exempt
for a
in all
minute over
cases.
there. Just pause over there. Transaction between a holding company and its subsidiary, one needs to see whether the subsidiary is a wholly owned subsidiary or other than a wholly owned subsidiary. If the transaction is between the holding company and a wholly owned subsidiary, it's clearly exempt under section 188, and in case of a listed company as per regulation 23. There is no exemption under section 177. So therefore approval of audit committee will be required under the provisions of Companies Act, but it will be exempt under 188 as well as under LODR. However, if it's a subsidiary which is not a wholly owned subsidiary, then it is certainly covered under section 188 as well as under regulation 23 of LODR, which means you need to see for the purpose of 188 as to whether it's a transaction in the ordinary course of business or an arm's length basis, and for the purpose of LODR you need to see whether it's a material related party transaction. Ranjit, does that answer the question?
Yes, I think a lot of confusion is there because another question is coming. Section 276 subsection 8 is
Right.
not applicable to private company. Friends, madam has already clarified that applicability of private company is there for 188, 2 subsection 76 also. 5th June notification is something else which is dealing. I'll request madam repeat it again.
Sure.
That
Okay, we'll just take this question in 2 minutes. Let us get this notification. Let us get this notification of 5th June as to whether this particular section is exempted.
Yes.
And if it is not, then it certainly
You
is
proceed
applicable.
further then.
Okay. So going back to, I think there have been a lot of questions and I really am enjoying answering so many questions, I must say. Okay. So we were on disclosure which is required to be given. Mind you, the disclosure provisions, as I mentioned a little while ago, also needs to be linked with section 167 of the Companies Act, which deals with vacation of directors, and as I said, 167, 1C and D are two relevant provisions. In fact, under section 167, with respect to vacation of directors, there are 3 specific provisions which one needs to bear in mind when you're referring to related party transactions. One is about disclosure, which is C and D, and the second one is with respect to participation in a discussion with respect to related party transactions, which is also D, as well as there's one more provision there. Just give me a second, let me just, I'm sorry, it's only C and D, 167, 1 C and D, where he acts in contravention with respect to disclosure or where he participates in the discussion where he is interested. And these are very serious provisions because the director ceases to be a director because he vacates office. So with respect to disclosure, one needs to bear this also in mind, that he needs to ensure that there is no transaction with a related party. Disclosure of interest is required to be given at a meeting of the board of directors of the company, while a general notice of interest in MBP 1 in form MBP1 can be given by the directors. The director, when a person is appointed as a director, at the first board meeting held after his appointment, the notice of interest of the director must necessarily be considered and noted by the board. And going by section 184(1) of the Companies Act 2013, at the first board meeting held in the financial year, in every financial year, the notice of interest should necessarily be taken up by the board. And if there is any change in the interest of directors, the same needs to be communicated to the board from time to time. This change in directorships is required, or change in interest in directorship is required to be communicated within 30 days of a change occurring, and this is also required to be communicated to the board. And as you are aware, as per section 189 of the Companies Act 2013, read with rule 16 of the company's meetings of board and its powers rules, this provision with respect to disclosure of directors is required to be entered in the register of contracts maintained by the company. I'll come to register of contracts a little while later. There are two parts to the register of contracts, and only those entries are required to be made, but we'll come to that a little later. So as I said, disclosure of directors linked with vacation of office, and the disclosure is required to be given in form MBP1. 184(2), which is an important provision, specifically provides for certain types of interest which are required to be disclosed. If you observe in section 184 subsection 2, there are two subsections, which is A and B, where or you could call it clauses A and B. And if you observe the structure of section 184(2), it actually deals with interest of the director. Although it refers to the term directly or indirectly, it's actually interest of the director. What I'm trying to emphasize on is the fact that section 184(2) deals only with interest of the director and not of his relatives. And if you refer to 184(2)(a), it refers to a situation where the director is holding more than 2% of the paid up capital of any other body corporate, or is the promoter, CEO, manager of the other body corporate. And the second one is where he is the owner or a partner in a partnership firm. So therefore, 2% limit, and of course 184(2) 2% limit, as I mentioned a little while ago, 2% limit has to be considered by considering the holding of the director along with other directors on the board. But going back to the basic provision, it's actually interest of the director and not of the relatives, which is covered in section 184(2). And this is a very important provision because it's relevant to consideration of quorum as well as participation of the director in the meetings, which is a question which has cropped couple of times in this webinar today. I have the notification right in front of me, and yes, with respect to a private company, subclause 8 of section 2 subsection 76, which was a point which was raised over here, it says shall not apply with respect to section 188, which means this 276(8) deals with a company which is a subsidiary or an associate company of the second company. Now section 2 subsection 78, as I mentioned, this particular section 276 is also covered in the Companies Amendment Bill of 2016, and 276(8) is proposed to be amended. But having said that, any company which is a holding subsidiary or associate company of such company will be a related party, and in case of a private company, a holding subsidiary or associate company which is a private company will be exempt from the provisions of section 188, which means if the subsidiary company is a private company, then you need not comply with the provisions of section 188. Let's now go back to the question, Ranjit.
Yeah. Since you have already given the legal provisions, now repeat the question.
Sure.
Section 276(8) is not applicable. That's
Right.
fine. Section 188 wide exemption notification dated so and so. This means a holding and a subsidiary oblique associate will not be taken as a related party for the purpose of 188 if they are private companies. Situation, now let us suppose that there is a holding company H Private Limited and subsidiary company S Private Limited, and there is a common director Mr. D. Question 1, whether in the above situation the exemption of section 276(8) holds good, because 276(7) common directors also come into place. So that is question number 1.
Okay. Yeah, go ahead.
Question number 2, whether exemption given to private companies under 76(8) for holding subsidiary with respect to 188 holds good if any other clause of section 2 subsection 76 also come into picture simultaneously. So that there is a conflicting section, like private company exemption has been given, but
Right.
if other relationship provided under section 2 subsection 76 establishes, so whether that particular exemption, specific exemption given to private company, limited company still hold good or not. So that is a very good question, I must appreciate.
Excellent. Okay, let me just repeat the question once again in just one sentence. If there is an exemption which has been granted exempting one particular provision of the Act with respect to private companies, any other subsection or provision of that section would also be deemed to have been exempted? Answer is absolutely no.
No.
All that it says, if you refer to the exemption notification, all that it says is that if there is a holding company which is a private company, and if there is a transaction with a subsidiary which is also a private company, then this particular subsection 76 of section 2 subclause 8 is clearly exempted in its applicability with respect to section 188. Of course, the holding company may be a public company is what you would immediately think of. There is a bit of a grey area there. Going by section 2 subsection 71 of the Companies Act, if a company which is a private company, if it is a subsidiary of a public company, then it will be deemed to be a public company for the purpose of Companies Act. So, if S Private Limited were to be a subsidiary of H Limited, then going by section 271, S Private Limited would have automatically become a public company. Hence, in my example, I used H Private Limited and S Private Limited, which is very similar to the question that has been raised before me. Once again, going back to the question that has been raised, there is a transaction between H Private Limited and S Private Limited, and going by section 2 subsection 76 subclause 8, this transaction will not fall under section 188 because there is a clear exemption. But if one of the directors of H Private Limited is also on the board of S Private Limited, then provisions of 276 4 will get attracted, and that is not exempted. But in such a scenario, under 184(2), you have a clear relaxation where the interested director needs to make mention of his interest in the transaction and thereafter participate in the discussion.
That means transaction is exempted when a particular deal or sale or purchase transaction is being done between the holding company and subsidiary company as such.
That's
not
right.
between the company and director or any of the company in which that particular director is interested.
That's right, absolutely. I must also acknowledge that this question has a very important implication where if it's a subsidiary and the transaction is exempted, why should it not be exempted under 276(4)? I would actually pause over here and state that I'm only interpreting the provisions of the law the way it exists today, and this certainly is a good point which could be considered in future.
Yes.
Yeah. Was there another part to the same question that we did? Yeah.
Another. I think you have answered the whole question in totality.
Wonderful.
Because
Okay.
Next.
That's fine. Okay. As I was mentioning a little while ago when I started my session on interested director, while it refers to interest directly or indirectly, as I mentioned a little while ago, as per section 184(2), it's only direct interest of the director which is considered. Yes, I am aware that 184(2) refers to directly or indirectly also, but it's only interest of the director and not of his relatives. If you refer to section 2 subsection 49, it's a term which has a slightly broader meaning in comparison to section 184 subsection 2. If I were to use a cliche, I would say that an interested director may not be a related party in all cases, because an interested director would be considered as a related party interested in a particular item only if he is interested by virtue of section 184(2). I think we've also covered section 174, which deals with quorum. Audit committee provisions, of course, is not clearly under the purview of this session, and I think I'll be digressing from the topic if there were too many issues with respect to audit committee, constitution and the like, but I would just like to mention a specific point that there is a distinction between constitution of the audit committee under the provisions of Companies Act in comparison to the provisions of LODR, because under LODR you need to have at least 2 independent directors to be present at every meeting of the audit committee to form quorum. So it's not just majority of directors, you need to have at least 2 independent directors. So companies which have a very lean audit committee constitution need to be very careful to ensure that the audit committee has necessary quorum if they are listed companies. Of course, if they are not listed, it will only be as per the provisions of section 177 read with the rules. Related party transactions, can they be approved by passing circular resolutions? Since the notice of interest has to be, disclosure of interest has to be made at a meeting of the board, discussion under section 188 also needs to be made at a meeting of the board only, and therefore it needs to be passed at a meeting of the board only. But what about audit committee meetings? If there is no bar, can they be passed by circulation? I would state that there is no specific provision which says it cannot be passed by circulation. Having said that, a general cardinal principle with respect to passing of resolutions by circulation is that you need to distinguish between items which require discussion by the board or by the committee vis-a-vis items which do not require discussion and can be decided based on papers. And if it is one which can be decided just based on the documents before the board and the board members, it can be passed by circulation. But such matters with respect to related parties, apart from the ones falling under 188, even 177, one would prefer to pass it at a meeting of the audit committee, although the Act is silent with respect to such issues. Loans by banks. Very often, banks have a term in their loan document as well as in their term sheet stating that a loan granted to a subsidiary will be guaranteed by the parent company. So, a corporate guarantee which is given by the parent company to secure the loan which is granted to the subsidiary. A subsidiary which is not a wholly owned subsidiary is what I am referring to. If it's a wholly owned subsidiary, you don't require any approval under 188, although as I said 177 approval would be required. So if it's not a wholly owned subsidiary also, it's clearly permitted, and such a guarantee can be granted by the provisions of according to the provisions of Companies Act. Question here is, will this grant of corporate guarantee be treated as a related party transaction? Of course, it will be treated as a related party transaction and needs to be approved by the audit committee, and thereafter it will need only an audit committee approval. It will not require a board approval because it's in the ordinary course of business and on arm's length basis. There is no specific this over here. So therefore, it will only require audit committee approval. But yes, it is a related party transaction which needs to be noted. There's also another interesting question. I'm not sure, Ranjit, whether such a question has been raised, whether salary that is proposed to be paid to whole-time directors is a related party transaction or
Yes,
not.
this question is already there.
Okay.
So you not only salary relating to ordinary whole-time directors or managing director. This question is relating to salary paid to the CFO, CEO, company secretary, whole-time directors, managing director, and also related to these KMPs.
Sure.
So kindly address this particular topic,
Right.
whether salary paid to the directors and all other KMPs and also their relatives are covered under the related party transaction or not, whether approval under section 188 will be required, whether it will be requiring approval of section 177 under audit committee under section 177
Sure.
or LODR related provisions. So complete detail is required.
Wonderful.
In this particular transaction.
Okay. Let's assume Mr. X is proposed to be appointed as a whole-time director in a company. Going by the provisions of section 196, you would certainly require approval of the nomination and remuneration committee, and thereafter it will have to be placed before the board for its approval. Ordinarily, there is no touch point of referring the matter to the audit committee if this person is completely unrelated party and is proposed to be appointed as a whole-time director. In this particular case, if a person is proposed to be appointed as a whole-time director and such appointment is approved by the recommended by the nomination and remuneration committee and comes up before the board and the board considers the appointment, it of course needs to be approved by the shareholders also, which then comes up before the shareholders at the ensuing annual general meeting. Here, at the time of appointment, the person concerned is not a related party and therefore there is no related party transaction in this particular case. Let us consider a second situation where Mr. X, who is proposed to be appointed as a whole-time director, is a relative of Mr. Y, the promoter of the company, who is also a director. In this particular case, it's clearly a case of a related party transaction and therefore would need to go through the NRC, audit committee and thereafter to the board as per section 196. So it goes to the NRC going by the provisions of section 178, it goes to the audit committee under 177 and then it goes to the board. What should be the order in which it travels from one committee to the other? Should it be the NRC first and then the audit committee and then the board? I would say yes. Although there is no bar on the audit committee approving subject to the approval of the NRC, it would not be a right practice. It needs to go to the NRC first because appointment of a person to the board requires approval of the NRC and the NRC would see whether the person is complying with the criteria which has been laid down. So therefore the NRC's approval and recommendation will be the first step. Since it is a related party, it goes to the audit committee and after the audit committee also recommends it, it goes to the board. This is a case where it's a related party transaction and since a person is proposed to be appointed to the board, this would need to be analyzed in light of the explanation to section 188(1), whether it is in compliance with schedule 5 read with section 197 of the Companies Act or not. If it is in line with that, then the board approves it and then it goes to the shareholders in the ordinary course under section 196 of the Companies Act 2013. Let's take a case where a relative of a KMP is proposed to be appointed. No matter what the post be, appointment of a relative of a KMP, this relative is a related party and such an appointment will therefore need approval of the audit committee. It may not require approval of the NRC if the person is not being appointed as a whole-time director or if the person is not being appointed to a senior managerial personnel's post. So if he is not a senior managerial personnel, then it does not have to go to the nomination and remuneration committee, but it certainly needs to go to the audit committee and thereafter, depending on the limits, it will need to be placed before the board or otherwise. Disclosure, since it's a related party transaction, disclosure as was explained a little while ago will need to be complied with. Remuneration of CFO, CEO and the like are actually employees of the company. They are in the employment, CFO, CEO, CS, they are KMPs of course. Transactions with KMPs is of course a related party transaction, but there is no specific transaction when an increment is given. A transaction is when you accept your letter of appointment. Thereafter you get your increments in accordance with the provisions of the policy of the company, and you also have the remuneration policy with respect to senior management personnel in case of listed companies, which is required to be disclosed in the schedule 5 in the corporate governance report, where you give details of remuneration policy. It's also on the website of the company. So therefore, if the increments are in consonance with this, there is no further disclosure that is required. Talking of remuneration, I would also like to refer to section 197 as well as provisions of LODR with respect to stock options. Companies Act 197 says that stock options cannot be granted to independent directors. The board broadly comprises of executive directors and non-executive directors. Stock options cannot be granted to independent directors, and independent directors are actually a subset of non-executive directors. Non-executive directors may comprise of independent directors and other non-executive directors who are not independent, which actually means, going by section 197, non-executive, non-independent directors can be granted stock options. Going by LODR, regulation 17, sub-regulation 6, I think it's 6A and B of LODR, if any stock options are given to directors, then non-executive directors, then it requires approval of the shareholders. Whenever stock options are given, it in any case is in accordance with the approval granted by the shareholders. But what is important to note is that the maximum that can be granted in any 1 year as well as the maximum in aggregate that can be granted needs to be specifically approved so as to ensure that it falls under regulation 17. Regulation 17 is basically with respect to powers of the board and of LODR, and this needs to be approved by the shareholders. So long as this is being complied with, non-executive, non-independent directors can be granted stock options. There is no bar either under Companies Act or under LODR in granting this.
Two related questions in regard to company secretary and other KMPs.
Sure.
First is CS salary is also required to be disclosed under related party transaction, number one. Number two, taking this question forward, if company secretary of the company does some other services, managing other companies and other services also, is it required to be disclosed the full value of salary of CS as RPT? Third question, related question, that if they draw over and above for performing some extra functions, say as a CFO or some technical expert, whether that will be covered under RPT and it is required to be disclosed under RPT.
Okay. See, if the CS or any other KMP performs any other services, are you getting an additional amount as remuneration, or is it under some contractual payment which is being made? If it is under remuneration, in any case the term remuneration covers everything that you get.
Yes.
So therefore, it will be just one lump sum amount that you are referring to.
But it should not be place of profit.
Yeah, it will not become a place of profit. If the CS is only an employee, then there is no specific limit which has been placed over there, so long as it is within the remuneration policy of the company. So if it's within the remuneration policy limits, then limits are never in terms of monetary limits.
Say for example, I am say CFO of the company, and I am also having the technical expertise of IT, and I have given the charge of IT on a contractual basis, say for example 2 years you handle the IT services,
Right.
and for that X amount will be paid by the company
Right.
to you as a consultant, or say particular for handling that particular assignment,
Right.
whether it will be considered as place of profit or not for that particular employee and KMP.
Right. Now, when you're given this particular contract to manage IT, is it a separate agreement where you are
Yes,
getting a
yes.
separate amount which is treated as a payment towards a contractor or payment for professional services under section 194 of the Income Tax Act? If yes, it's not forming part of your salary. In your income tax return, you have to see whether it's forming part of your salary or it is forming part of income from other sources or income from your business or profession.
Yes.
If it is a separate head, yes, provisions of officer place of profit
Will
will
be
get
applicable.
attracted. So, I would use an income tax test to see whether this will fall under the provisions or
Absolutely,
not.
absolutely.
Also, sometimes a CS or an executive of the company, maybe a CFO, CS as the case may be performing something with respect to other group companies. The question to be seen is it a transaction between the company and the related party? Please don't lose sight of the fact that section 188 deals with transactions between the company and the related party. The two parties to the transaction need to be the company and the related party. If it is a transaction between Mr. X and the associate company or Mr. X and the subsidiary, the company has nothing to do with this transaction. So, it will not be a related party transaction at all. So, this is something which needs to be.
I think this is the question. One person has asked the same question. If
Right.
a company, a person is appointed as whole-time director and CFO of the company and is paid salary, then whether this director is said to hold the place of profit in the company, because his salary does not contain any bifurcation as to payment of salary to director or and CFO separately. So I think the same question.
That's right, yeah.
Criteria of income tax, whether you are getting salary or it is beyond the employment contract or within the employment contract.
Absolutely.
If it within the employment contract, it is covered under say of course
Absolutely.
not under 188, it is exempted.
Right. Let me take a bizarre case where a person who's a KMP also has a business of maybe supplying computers, and the company enters into an agreement with this KMP for taking few computers on hire basis. This would certainly be a case of officer place of profit, because the person is getting something in addition, because it's a transaction with a related party, and if it is a sole proprietary concern, definitely will have to be considered based on this particular transaction.
I have
Now here of course one could say that supplying computers could be considered as leasing of property, and therefore it could be covered under 188(1)(c), and therefore one will have to go by the limits given over there. Absolutely right, one will have to go by the limits given over there under 188(1)(c) and not under 188(1)(f), and see as to whether it falls under 188 at all or not. Whether it falls under 188, which requires board approval, if it is with respect to hire of computers, yes, you will certainly require approval of the board. You will need to see whether you require approval of the shareholders or not, depending on the threshold which will need to be considered.
I think I have received more than 200 to 250 questions. So quickly, I think you should run through the legal provisions, and
Right.
then we will concentrate totally on the questions only.
Absolutely fine. Okay, I was on the loan given to a subsidiary where the parent company gives a corporate guarantee. The section as well as the rules, Rule 10(2) of Chapter 12 rules, specifically refer only to subsidiary and not to associate companies. So therefore, if it's a loan which has been granted by the bank or the financial institution to the subsidiary and the parent company gives a corporate guarantee, that alone would be permissible. And as I mentioned a little while ago, yes, this will amount to a related party transaction and will require approval of the audit committee. And this would okay, we've covered section 177, 188 disclosure. Let me move on to register of contracts and rule 16. there are three specific heads under which entries in the register of contracts need to be considered. One is plain and simple disclosures made by the directors which need to be entered in the register of contracts. Second is if the transaction is one with a party covered under section 184(2) of the Companies Act 2013. Now, as I mentioned, I've explained 184(2) sufficiently. If it's an entity which falls under 184(2) disclosure, then such a transaction needs to be entered in the register of contracts. The third, of course, is if the transaction is one which falls under 188 of the Companies Act, which basically is one which is not in the ordinary course of business or not on arm's length basis, then it needs to be entered in the register of contracts. Going by section 189, if the transaction value does not exceed 5 lakh rupees in a year, no entry is required to be mentioned in the register of contracts. Now, this is a very tricky provision because during the year you would never know as to whether the transaction is likely to exceed 5 lakhs or not. So, how does one determine as to whether it should be entered at all or not? If it is a small amount and it builds on and exceeds more than 5 lakhs, then you would actually have to make all the entries right from the first day. So therefore, this 5 lakh limit, one needs to see as to whether the transaction is one which is likely to exceed. And of course, there is nothing wrong in erring on the side of caution and making all the entries if it's with a party which is covered under 184.
Just want to stop you here.
Sure.
There are two questions on section 189.
Sure.
So related topic is being dealt with, so I should ask the question.
Right.
Section 189 requires entry of all related party transaction to which section 184 or 188 applies.
That's right.
Now, Form MBP4 requires to write whether transaction is at arm's length. Being an arm's length transaction, section 188 does not apply and I need not make entry. Then whether MBP4 arm's length column is only for the purpose of section 184 transaction. That is one question. Another question is whether entry to be made in register under section 189 for transaction in ordinary course and arm's length basis. Since the wording used is all contracts or arrangement to which section 184(2) and 188 applies, in case of transaction in ordinary course and arm's length basis, section 188 applies but exemption is given from the board and shareholders approval, whether entry in the register will be required or not.
Good question. Okay. When you refer to entry in the register of contracts, of course, one is about disclosure. I'm not going to be covering the disclosure part because that's a straitjacket provision which I'm sure is very well understood by everyone. If it's a transaction with a company or an entity to which 184(2) applies, then it may be a transaction where 188 is also attracted, or it may be a transaction where 188 is not attracted.
Yes.
For example, let's assume a case where Mr. A is a promoter of B Limited and the transaction is between A Limited and B Limited. A Limited being the first company in which Mr. A is a director and B Limited is a company where Mr. A is one of the promoters. This is a case which clearly falls under section 184(2)(a) and therefore needs to be entered in the register of contracts going by 189 of the Companies Act read with Rule 16 of Chapter 12 rules.
Yes.
This particular transaction may be in the ordinary course of business and on arm's length basis, in which case it may not require approval of the board or the shareholders under 188.
Yes.
I'll come to 188 in just 2 minutes because to which 188 applies is one which needs to be interpreted once again. So here, based on this particular provision, 184(2), the entity is one which is covered under 184(2), I'm sorry, and therefore requires entry in the register of contract. Let's go on to 188, a plain and simple one, a transaction which is not in the ordinary course of business or a transaction which is not an arm's length basis certainly falls under 188 and therefore requires an entry to be made in the register of contracts. let's consider a situation, this was a plain and simple one. Let's consider a situation where, going back to the example of Mr. A, who is a promoter of B Limited and where he is also a director on the board of A Limited. Now, let's assume this transaction of A Limited with B Limited, as I explained a little while ago. Question to be considered is it a transaction covered under section 188? What is a transaction covered under 188? Does it mean a transaction which requires approval of the board and of the shareholders under 188 is the one which is said to be covered under 188? Or just because it's a transaction with related parties, will it be said to be covered under 188? There are two schools of thought on this particular issue. My personal view is only if you require approval under section 188 would it be said to be falling under 188, because there is a very clear provision that a transaction which is in the ordinary course of business and on arm's length basis will not require approval of the board or the shareholders, as the case may be, under 188. If you refer to 188, let us just quickly refer to 188 just to be technically, 188, the third proviso very clearly states, provided also that nothing in this subsection shall apply to a transaction entered into by the company in its ordinary course of business other than transactions which are not on arm's length basis. So, going by the third proviso, if you have met the two tests of ordinary course of business and arm's length basis, then nothing in this section shall apply. So, if nothing in the section applies, would it still be said to be covered by section 188 is a technical interpretation where I would hold you would not require.
I am taking it forward.
Right.
Section 188 is not applicable because transaction is at arm's length or ordinary course of business.
Right.
Though it is arm's length transaction, but a specific exemption has been provided under the said provision, third proviso. However, register of contract arrangement in which directors are interested is talking about section 188 applies. So, wherever section 188 applies, entry is required to be made. If it does not apply, then in that case also, whether entry is required to be made or not, that is the question. Right. So, I think entry will not be required to be made.
Yeah. Entry, in my opinion, will not be required to be made because it says nothing in the subsection shall apply. So, therefore, it does not apply.
And 189.
However, there are two views today in the market. I would say that since 189 clearly states 188 applies, 188 shall not apply is what the third proviso says, and hence I would say entry is not required.
Yes.
Right. Okay. That was an interesting one. Under LODR, Schedule 5, Part A refers to loan which has been granted to an entity which entity in which the director is interested. You would also note that under section 185, if a director is concerned or interested in an entity, a director would be the technical term used in 185 is that any person in whom a director is interested is the specific technical term which is used. So, if a director is interested in any other person, the company cannot give a loan at all. And the categories of persons are a director of the lending company or of its holding company, or a firm in which the director is a partner, or a private company, in fact it says a private company in which the director is a director or a member, or a body corporate, and the other 2 points of body corporate is basically with respect to the control. So, a director cannot be granted a loan, a partnership firm in which the director is a director cannot, a partnership firm in which the director is a partner cannot be granted a loan, a private company in which the director is a director or a partner or a member cannot be granted a loan. These three related parties cannot be granted a loan, which is fine. Is there any other category which is covered under Schedule 5 para A, which is not covered under 185. That is there any other entity to which a loan can be granted under 185, an entity to which 185 prohibition does not apply, which is required to be disclosed in the corporate governance report as per schedule 5 of LODR. I would say that if it's a loan to any other public company where the director does not hold more than 2%, for that matter public company clearly is not covered under 185 unless it's one where there is control or the other two provisions. So therefore, in case of a public company, it could even be one where the director holds more than 2% and therefore becomes an interested party, interested director in such a transaction, but it is approved by the company. It will require disclosure under LODR as per schedule 5 para A, because there is a clear reference, and in such a case the borrower company, if the borrower company has any investment in shares of the lending company or its subsidiary or associate company, all these need to be clearly disclosed. MBP 1 we covered, and I also mentioned it as a disclosure at a meeting.
MBP 1,
Sure.
elaborate a little bit,
Right.
because there are questions on
Let's
which
address
date
the question.
MBP 1 is to be given by the director. Should MBP 1 dated 1st April or first meeting of the board in every year? So that is two questions. One is when it is required to be given, what should be the date put it on the MBP 1? Second question. Third question, whether it should be containing the date of approval or date of giving by the director or tendering by the director. Fourth question is that MBP 1, if it is not approved in say meeting of the directors, say first meeting of the directors, whether it can be ratified in the subsequent meeting of the board.
Okay. Let me take the simple ones first. There were 5 questions. What should be the date of MBP 1? The date when the director gives it is the date that has to be put in on MBP 1. When it should be given, 184.1 is very clear as to 3 circumstances where disclosure is required.
Hello.
First is when a person is appointed as a director, then at the first meeting he has to ensure, which he attends, he has to ensure that the notice of disclosure is placed before the board. So any time before the first meeting of the board after his appointment, he needs to ensure that MBP 1 is given. Second is every year, every financial year, at the first meeting, this notice must be considered by the board, which means before the first meeting, the disclosure must be given. Now, in case of a listed company, actually this disclosure, while it may not necessarily be in MBP 1 format, disclosure of interest actually gets updated almost on a quarterly basis. Every quarter you do take the details, because in the corporate governance report as per regulation 27(2), you are required to give details of other companies. It's not as elaborate as MBP 1, but at the same time you do take those details. So coming back to MBP 1, every year it is required to be given. What should be the date? The date on which the director gives it should be the date. First, it should definitely be before the date of the first board meeting held in that particular financial year. When should it be given? So there are, the third one is wherever there is a change in the interest of the director, it needs to be once again communicated. Change needs to be communicated within 30 days of the occurrence of the change. Now this 30 days is the maximum period. It might well so happen that there is a change and in a week's time there is a board meeting of that company and there is a transaction with the company in which the director has acquired interest, in which case the 30-day period will get truncated to 7 or 8 days when the board meeting is going to be held, and he has to mention about his interest and also give the disclosure. So that's with respect to when it has to be given. The date of giving actually gets covered in the earlier 2 points that I just covered, Ranjit. When should it be noted by the board? It should be noted, actually it's not an approval by the board, it is noting by the board. There is no approval to be given by the board. So it's a noting which is done by the board the moment it is placed. At the meeting at which it is placed, the board notes it. So every year at the first board meeting, every financial year at the first board meeting, the board notes the disclosure given by all the directors of the company. What happens if it is not noted at the first meeting and is noted subsequently? Well, the law clearly mandates that it needs to be placed before the board at the first meeting of the financial year. So it's also the duty of the director to ensure that it is placed before the board at every at the first meeting of every financial year. This is one of the compliance issues, and going by section 205 of the Companies Act, compliance is something which the company secretary as well as the board of directors will have to ensure. So therefore it's a duty of the director, and in case of a company which has a company secretary, I would urge all the company secretaries to ensure that this is a mandatory item that you consider at the first meeting of the financial year, first board meeting of the financial year. In fact, it's slowly digressing from the topic of related party. I would say that from a good practice perspective, it is good to have standard agenda items created for the pre-planned board meetings of the year. You would of course keep having new items because business is dynamic, but at the same time you can at least have standard notice, standard agenda and standard minutes, because it's discussion which needs to be put in. The format need not be changed every time you have a board meeting. So the moment you have these kind of standardized items of notice, agenda and minutes, it's only the ones which require discussion which then need to be considered. Don't have just one standard item or one standard agenda, notice and minutes. You need to have at least 4 if you are proposing to have 4 board meetings a year in your company. If you are proposing to have 6 board meetings a year, please have 6 standard notice, agenda and minutes, because the numbering would change of the board meeting. There are other items which need to be considered. So you may have standard items of business also. So if you do this, you would never miss out, and therefore the question of not considering at the first meeting of the financial year will not arise at all. Okay. Also, just to add, the register of contracts is a register which is required to be kept permanently. In case of listed companies, you do have a policy under Regulation 9 of LODR which deals with records which needs to be maintained by the company, policy on retention, preservation and disposal of records, and documents which is actually supposed to contain 2 specific provisions, one with respect to documents which are required to be kept permanently, and second with respect to documents which are required to be kept for 8 years. I would also hasten to add that Regulation 9 of LODR in my view relates only to documents and records under LODR, but it will be a good practice to actually extend it to all other statutory documents and records which are required to be necessarily kept, and distinguish them under 2 heads of records to be kept permanently and records to be kept for a period of 8 years or above, and have this classification clearly done. So register of contracts needs to be kept permanently. It's a document which is a permanent record. Who is entitled to take inspection of register of contracts? Any member of the company can take inspection, and you may prescribe fees which may need to be paid by the person. If he asks for any extracts of the register of contracts, the company is duty bound to give it, and it needs to be given within a period of 7 days of such a request being made. And entries, at what frequency should the entries be made? The rules say that the entries need to be made, shall be caused to be made as and when they are required to be made. So which means whenever there is an entry which is required to be made, you need to make it. I also would have a point to mention over here. What is a transaction? If you have a master PO which specifies a particular limit and you have subheads of POs, are you required to enter maybe 50 or 100 subhead numbers of POs, or is it sufficient if you just have the master PO entered? Different companies have different practices, but if you have repetitive transaction and you have given one master PO, then it's fine to have the master PO recorded and at regular intervals just have the attachments kept in your file, which will be a supporting, which shows that up to so much has been up to so much in value has been approved. Authentication of the register of contracts is required to be made by the company secretary or by any other person authorized by the board in this behalf. So if it's by the company secretary, no further authorization is required because there is a statutory recognition there. But if it is by any other person, then you require authorization by the board as to the person who is authorized to authenticate it. The register of contracts shall be maintained at the registered office of the company and shall be in the custody of the company secretary or any other person authorized by the board. Of course, when you say it's in the custody of the company secretary, it's just that the company secretary is responsible for maintenance of all the statutory records. It's not in the physical custody, but you're responsible and accountable for the maintenance of the register of contracts, and you need to be responsible and accountable for ensuring that the register of contracts is properly kept and maintained. So that's broadly with respect to the register of contracts, and rule 16 is the relevant rule in this case.
Should I go now on the questions?
Yeah, I would also like to cover section 192 of the Companies Act 2013. If the transaction is one which is quantified in rupees, it gets covered under 188 read with rule 15.3. 15.3 basically prescribes the limits 10% of turnover or 100 crores. If the transaction does not exceed 10% of turnover or 100 crores, then whichever is lower, then it will be within the authority of the board to approve such a transaction. If it exceeds this limit, it will have to then go to the shareholders, of course only if such a transaction is one which requires approval of the shareholders under section 188, which is a transaction which is not in the ordinary course of business or a transaction which is not on arm's length basis. So just to sum up, if it's a transaction which does not exceed 10% of turnover or 100 crores, whichever is lower, the board would be authorized to approve, although it may be a transaction not in the ordinary course of business or not on arm's length basis. I give just 10% of the turnover or 100 crores, but you also have other sublimits, like say for example 188(1)(c), the limit is with respect to net worth of the company, or you have the limit with respect which is lower at 50 crores in case of an agent, and so on. But broadly the limits are what are given under rule 15.3. Rule 15.2 of chapter 12 rules is also something which is very important to be considered. When is a director required to step out of the room where the meeting is being conducted? If the director is a related party to a transaction which is being discussed, the director who is a related party needs to move out of the room and he will not be counted for quorum on that particular item of business. He would not be entitled to participate. If the director is interested in an item of business but is not a related party, then it's not one which falls under 15.2. I repeat, a director may be interested when he is being appointed, let's say when his increment is being discussed by the board of directors of the company. In this particular case, if it's in the ordinary course of business, in accordance with the limit which has been already approved by the shareholders earlier, it's not a related party transaction, because the explanation to section 188 very clearly states if it is in accordance with the limits under 197 and schedule 5 of the Companies Act 2013, it will not be said to be an office or place of profit, and therefore it will not fall under 188 at all. So in this particular case, he doesn't have to go out, strictly speaking, going by rule 15.2. Of course, certain companies and certain directors do have their own practices and may opt to move out. So if it's only a transaction in which the director concerned is a related party, will he need to go out. If he is just interested but is not a related party, need not go out. So that's 15.2 and 15.3. I wanted to cover section 192, where a transaction is between the company and a director, with respect to a transaction which is not for cash. It may be for services rendered by the director, that something is being given in kind, or where a property is being acquired and maybe shares are being issued in lieu thereof, and so on. It will fall under 192 and not under 188. And 192, every case will require approval of the shareholders. So transactions not for cash covered under section 192 is also very closely linked and related to related party transactions.
Yes.
So that's,
I think we should take questions
yeah,
now
that's
one
fine.
by one.
Okay, there are a couple of
There
points
are-
on LODR, but
I
maybe
think
we
if
could do this
time will
and
permit, then we will
yeah,
definitely go on
sure,
that. So, lot of questions are there, so let's address the questions first.
Sure,
Section 177(4)
yeah,
sub clause 4
yeah,
of the Act requires audit committee approval on any transaction entered into by the company with its related party, including subsequent modification thereto.
that's right.
Is the audit committee approval required prior to execution of the contract with the related party? So, question is, section 170 says approval, whereas 188 requires prior approval.
Right.
So, in which case prior approval is required and in which case prior approval is not required? This is the question.
Sure. If I were to once again repeat the question, as per section 177 of the Companies Act 2013, do you require prior approval of the audit committee before entering into the transaction? As per the provisions of Companies Act 2013, if you are not a listed company, you do not require prior approval. Going by a strict interpretation of the provisions of Companies Act 2013, I repeat, you do not require prior approval of the audit committee under Companies Act if you are not a listed company. If you are, however, a listed company, then you require prior approval of the audit committee as per regulation 23 of LODR. So, in case of listed companies, prior approval of audit committee is necessary. In case of companies which are not listed companies, prior approval of audit committee is not mandated as per section 177(4)(4). 188, however, mandates prior approval. So, if it's a transaction which is not in the ordinary course of business or not on arm's length basis, prior approval of board or shareholders, as the case may be, will be required to be taken. Does that answer the question, Ranjit?
I think little bit of confusion is there in my mind, in fact.
Sure.
Subsection 4 is talking about every audit committee shall act in accordance with the term of reference specified in writing by the board,
Right.
which shall inter alia include.
Right.
There are 4, 5, 6, 7, 8 situations.
Right.
So, all the situations should be dealt separately.
Correct.
Because first is recommendation of the appointment. So, recommendation has to be prior.
Correct.
So, I think answer to your fourth point, fourth clause may be right,
Right.
but they may not apply to other clauses as well, because
Absolutely.
recommendation is a prior. So, I
Absolutely.
need a little bit of the clarification on, further clarification on this particular point.
Okay, fine. So, as I was mentioning, Ranjit, it's only related party transaction which is covered under
And
177(4)(4)
Yes.
that the law is not very
Clear, huh.
clear as to whether it is prior approval or not,
Yes.
or rather the law gives you a leeway if you are not a
Leeway,
listed
yes.
company, that even if you take approval later, it's fine. However, if you see the proviso, it says provided the audit committee may make omnibus approval. Now, omnibus approval necessarily means you are taking prior approval. Just
Yes.
because there is a proviso does not mean that the leeway given under say 177(4)(4) is
section,
taken away.
taken
It's not.
away, yes.
It's not taken away. And hence, going by a strict interpretation of 177(4)(4), there is no bar.
That means, friends, if you want to take go by the omnibus approval, then you will have to go, of course, prior.
Right.
And if you want to go transaction by transaction, then you may take a leeway. I can say leeway, but if you want to follow the good governance and strict good corporate practices, then you should go for the prior approval even.
Right. It's always better to take, because when you take approval, the very fact that you're seeking approval means that you are asking for permission. And when you ask for permission, there is a possibility you may be denied. It may be granted, but at the same time there is a possibility it may be denied too, and hence it's always better to go for prior approval than later. However, going by the Act, if it's an unlisted company, you do have the flexibility of going later. You must also bear in mind that in case the audit committee does not approve, then the audit committee not approving,
Really
currently
peculiar
the Act
situation.
is a little silent. But this is exactly what the Amendment Bill of 2016 seeks to incorporate in section 177, stating that if it is not approved, the transaction will be voidable at the option of the company. So therefore, provisions which are very similar to what is contained in 188 is sought to be brought in section 177 by the Amendment Bill of 2016.
Yes.
Which has to be borne in mind.
Mr. A is a director of XYZ Limited,
Right.
has entered into transaction with ABC Private Limited on
Right.
11/4/2017. On the date of transaction, he is not a director of ABC Private Limited. Afterward, Mr. A becomes the director of ABC on 15th June 2017. Is it a related party transaction, and is RPT is applicable or not?
What's important to consider over here is it a transaction which is continuing, or is it a transaction which has concluded? For example, if the transaction between XYZ Limited and ABC Private Limited is one of sale of goods, and on the date when the transaction was entered into, as has been mentioned in the question, A was not a interested party, he was
Not
not
a
on the
related
board of
party.
ABC Private Limited.
Not a related
So,
party.
at that relevant point, it never came up for approval of the audit committee or any
Or board.
other or the board, as the case may be.
Yes.
And let's assume it was for sale of goods. Sale of goods have already happened, and the payment is now pending when A becomes a director on the board of ABC Private Limited. So the tail end of the transaction is yet to be completed, but the transaction from XYZ's perspective has been completed, and there is nothing further that needs to be done by XYZ Limited except to receive the payment. In this transaction, no further approval would be required. But if it's a transaction which is continuing, let's assume a situation where XYZ is supposed to supply goods on a monthly basis for a period of 12 months, and you've already completed, let's say, 3 months, deliveries up to 1st of June, and on 15th of June, A becomes a director on the board of ABC Private Limited, then for the remaining tenure, the transaction is yet to be done. So at that juncture, this would be brought up because you may be issuing separate invoices, and those could be treated as transactions forming part of the contract, and hence you would require this to be considered, and the entry in the register of contracts may also be required, subject of course to Rule 16, which I had explained a little while ago.
If a private limited company is engaged in the manufacturing of goods, provides IT services or treasury services to its group companies to have benefit of synergy, will it be considered as ordinary course of business? For example, a company appoints internal auditor of its group company also to conduct internal audit and pays for the internal audit services availed for the group company. Whether this kind of transactions are considered in the ordinary course of business or not?
This is a public company or a private company?
Private company.
Okay. A private company which has engaged internal auditors. It's a private company which is engaged in manufacturing of goods, and it provides IT services.
IT services.
Okay, fine. And so it's basically a transaction between this private company and its subsidiary
Company, group company.
Okay. Now, when you refer to it as group company, is it a subsidiary company or is it an associate company?
Not mentioned in the company. I think you can deal with both the situations, subsidiary as well as group company.
If it's a subsidiary, as was explained a little while ago, going by section 2, subsection 76, subclause 8, there's a clear exemption there. So therefore, the transaction between the company and the subsidiary will not fall under section 188. So therefore, the question requires no further discussion. But if it's a transaction between the private company and an associate company, which is not a subsidiary, then it will, let's see section 2 subsection 76. Section 2 subsection 76 It says any company which is a holding subsidiary associate company of such company. So associate is also covered, and therefore the exemption which has been given.
But group
needs
company
to
must be falling within the definition of associate company.
Exactly, exactly. So what is this? Because very often we
Group
come across
company is
terms.
a very vague term.
Yes, we come across terms like group companies, sister companies.
Sister concern.
So we need to understand that better, right? So that's one. But my question here is, if there are services which are provided, let's say for example, when you have a
management
group.
tool.
When you have a group, it is always synergistic to have several services being negotiated by the main company, but have each of these companies pay their own charges.
Yes.
Which is quite okay, so that you get the benefit. Like it's more like centralized buying, and all the
Say
other
compliance
group companies.
tool,
That's
one
right.
company buys and another company, all companies follow.
Exactly, that's right.
Yes.
So anyways, yeah.
Let's A is a wholly owned subsidiary of B,
Right.
and director and general manager of B is also director of A. So when B grants loan to A, whether it attracts RPT, so loan transaction will be covered under RPT or not, this is the question. If yes, then what compliances is required to be made, and including statutory register, both are private companies.
Both are private companies.
Both are private companies.
B as well as A are both
Yeah,
private
yeah.
companies,
And wholly owned subsidiary also.
and a wholly owned subsidiary.
Yes.
Fine. If it's a private company, section 177 will not be attracted unless it's a private listed company, which of course is also proposed to be changed in the Companies Amendment Bill, where you're going to say public listed company rather than just listed company. So coming back, if it's just a private company, and if A is a subsidiary of B, prima facie going by 276(8), it will be exempted with respect to the transaction. However, did you say there is a director who is a common director?
Yes, director is a common director.
Okay.
General manager of B is a director of A.
Okay.
So one company he is director, another company is general manager.
Okay. As a general manager, he is not a KMP.
Not a KMP.
So therefore, if you are seeing it from the perspective of which company is he a director?
But question is a little bit granting of loan.
Right.
So whether granting of, first of all, whether granting of loan will be covered under section 188 or not. So that should be the first
Granting
question
of
which
loan
will
would be considered as a financial assistance, and therefore I would say that granting of loan is a service
because separate
which
section is also dealing with this
yes,
particular thing.
185 will be specifically covered under that, and under 185 you would require necessary approvals. So just goods or materials, or it'll actually yeah, providing of any services, financial
It will not
assistance
be,
cannot
no.
be. So it will not be, but at the same time there's another point here. If he is a general manager in one and director in another, so let's see, the board of B Limited, where he is just a general manager, is considering this particular item. Hypothetically, it will not even go to the board, but let me just look at it. If I were to see it from the perspective of B Limited, B Private Limited, this person is not even on the board.
Yes.
So why should it be considered as a related
Yes, it is
party
not
at
a
all?
related party,
It is
right.
not a related party. The question therefore is, let's move to A Private Limited, where he is a director, and the other company is only a general manager.
General
so it's once
manager.
again not a
Yes,
related
not
party.
a related party
It's
at
not
all.
a transaction under related party.
But he,
And
in
loan
any
is
case,
also
it is
not
a
a
wholly
related.
owned subsidiary, so it will become related party.
Yes.
Another
So,
clause.
Yes, where it is a clearly exempted provision.
Yes. Materiality has not been defined in
We
Companies Act
covered it a
2007.
little while ago, where we said
No,
that.
the question is different. Do unlisted company need to comply with this?
Yes, of course, because this materiality which is covered under AOC 2 is not under listing regulation. As I mentioned, under regulation 23 of the listing regulations, that is LODR, materiality has been very clearly defined as 10% of the consolidated turnover. But with respect to AOC 2, the term materiality has not been specifically defined. So it's left to the company to determine as to what is material, what is substantial, and accordingly
Can a
make
private
disclosure.
limited company which does not have audit committee take approval, RPT approval from shareholders for 2 or more years by passing shareholders a resolution up to threshold limit of 5 crore? So, question can be divided into two parts.
Right.
Whether omnibus approval can be taken for 2 years or 3 years or 5 years. So any limitation on the number of years and any limitation on the number say amount or quantum of transaction. So it can go up to 5 crore or 10 crore or 15 crore. So this
Sure,
there
just
are two
read the
questions.
question once again, please.
Can a private limited company take related party transaction approval from shareholder for 2 or more years by passing shareholders resolution up to threshold limit up to 5 crores?
Right. When will a private company require approval of the shareholders at all? Needs to be seen. Assuming for a second it does require approval of the shareholders under 188,
Yes.
then there is no bar on taking a threshold limit and also providing for a particular
So can
period.
it go to 5 years or even 10 years?
5 years, yes. Actually, 10 years, there is no specific bar
No bar.
under Companies
Yes.
Act. Only with respect to 196 where it says 5 years, and also there is a specific provision you cannot reappoint before 1 year of expiry of the term.
Since time is less, so we will go a bit fast now. Whether all related party transaction, including the transaction falling under the third proviso of 188(1), are to be required approval of audit committee, since the words used in 7744 are approval or subsequent modification of transaction. I think we have addressed this.
We have
particular
addressed this.
question.
All
We have already
transactions do
addressed the
require.
question.
Yeah.
A transaction between two private limited company which are fellow subsidiary has common set of directors. Can both private company claim exemption under section 276(8), even though both company having same set of director is covered under section 276(4).
Which also I think we addressed. Yeah.
Material threshold we have
That's
already
right.
covered. If a director of a company hold position of a director in a public company and is a shareholder holding more than 2% as a nominee director in said public company, will it attract provisions of section 2 subsection 76 subclause 5?
Okay. If a director holds position as a director of a public company and is a shareholder holding more than 2%, as nominee shareholder, how is he a nominee shareholder when he is holding more than 2%? I presume
Yeah,
he
presume,
is.
yes.
I presume it's a case falling under section 89 where the ostensible owner is not the beneficial owner.
Yes, yes,
Maybe
yes.
he is a trustee of some trust or something where he is just holding it in that behalf. Well, section 2 subsection 76 does not specifically classify this as member holding 2% in what capacity. I would say go by the literal interpretation, comply. There is
Yes.
there is nothing wrong in having compliance where there is an element of doubt. Does the act specifically cover this? There is no specific clearance on this nominee shareholder. Section 89 of the Companies Act, which deals with ostensible owner being different from the beneficial owner, has not been clearly brought in, nor has there been any circular on this particular issue. Probably that's what is being referred to over here.
Company A is selling its business in India and overseas to buyer X. As a part of transaction, the Indian business of A is carved out and transferred to subsidiary for a consideration determined by valuation report. This part of transaction will be a RPT. However, can it be considered at arm's length, since the transaction is a consequence of contract with X and pricing it derived from the valuation report?
Well, if it's based on a valuation report and the valuation report has followed the standard principles and methodology, then and it is comparable to other such transactions in the industry, it can certainly be said to be
Yes.
an arm's length basis. What is important is if it is not in the ordinary course of business, in any case you will require approval of the board. So when the board is approving, the board would consider these issues also.
Another question. I think this
Of
question
course,
has
I'm
been
presuming you don't require
Yes.
approval of the shareholders under 188.
Yes.
I'm not going into the same repetition again and again. Yeah, please go ahead.
If a KMP participate in public deposits in a listed company, then as per SEBI LODR, is it required to get the prior approval of audit committee? This question has came thrice from the different participants.
Okay, fine. Excellent. I think what is important to understand is that when you are referring to related party transactions, it is just to ensure that a person does not abuse his position in a company, and which is the reason you have these safeguards. Coming back to this specific question, if you have public deposits, going by the provisions of section 73 of the Companies Act 2013, there is a procedure which is required to be complied with, and one of the integral portions of this procedure is approval by the board. And once the board has approved it, the person is merely participating in terms which are common to all others. So there is no extra benefit that he is getting. If he is getting an extra benefit, then it's a different issue altogether. If there is an extra interest which is being paid to him because he is a KMP, certainly you will require approval of the audit committee, but otherwise if it is exactly as per the terms and conditions, no further approval is required.
If a transaction exceeds the threshold limit provided under section 188 and rules thereon, which requires shareholders approval, can it be blanket approval? Can it be taken for a period more than a year? I think we have answered this question.
That's right, yeah.
Whether the audit committee can approve a RPT, that is fixing all the term of transaction except related party, that a transaction is approved to enter with any of the related party, whether this approval becomes omnibus approval or not.
Fixing all terms of the transaction except related party. So I think what the question says is that you approve all the terms without naming the related party with whom you are going to be approving. So basically the audit committee is saying that if you follow this particular criteria, you do not require my approval. Now if you go by section 177, I think in an omnibus approval, is it okay to just approve the terms without approving the name of the party? When an omnibus approval is granted, may make an omnibus approval for related party transactions proposed to be entered into by the company subject to such terms and conditions as may be prescribed. If you go to the rules, I think there is a reference to name of the party. I think it is rule 6A which was subsequently introduced. So you could just go to 6A of chapter 12 rules, meetings and board of directors, meetings and powers of the board.
Rule 6, yeah.
6A, yeah. All related party transactions shall require approval of the audit committee, and the audit committee may make an omnibus approval. Audit committee shall after obtaining specify maximum value of the transaction, maximum value per disclosure, review at regular intervals, transactions which cannot be subjected, repetitive audit. Okay, if you go to 6A4, it says the omnibus approval shall contain or indicate the following.
Yes.
Name of the related parties.
So question's answer is very clearly given.
Right.
That name has to be indicated in the transaction. While approving the transaction from with each related party, how much you want to transact, that has to be given.
Yeah, but what is also possible, possibly that's the intent of the question, maybe you give 3-4 names of related parties and the terms and conditions and the limit so that you have the flexibility. Yes, that is possible.
That is possible, yes. Then next question is, renting a space to wholly owned subsidiary or subsidiaries are RPT required approval of board and shareholders or not?
What's important is a transaction between a company and its wholly owned subsidiary in any case is exempt under section 188 and is also exempt under regulation 23 of LODR. So it's an exemption, it's one which is exempted. Yeah.
Next question is, can private company gives guarantee against loan taken by LLP in which relative of director is a partner? Private company.
Can private company give
guarantee against loan
taken by LLP? Will it not fall under 185?
I think it will be a 185 transaction, and separate session will be there on this particular topic. So this topic will be relevant in that particular session. How can we give salary to director's son who is working as an employee in the same company which is unlisted public company? What is the procedure to be followed? I think this is a related party and related party transaction as
That's
well.
Right.
If it is going beyond the threshold limit of place of profit, then approval will be required. Whether annual increment given to KMP is a related party transaction?
No, this was also explained so long as it is as per the remuneration policy. Ranjit, while the 185 question is not a part of this, I would just like to quickly answer. There is an exemption granted to private companies by virtue of the 5th June 2015 notification, provided the conditions given in the notification are satisfied. And then I'll now leave it for the session on 185.
The definition of related party in LODR as to which all activities can possibly be covered. Few examples.
Okay, actually under LODR there are three categories of transactions which are covered. One is with respect to transfer of resources or transfer of services or transfer of obligations. So transfer of obligations with would mean if there is an obligation undertaken by company A and it is transferring it to company B, it will be considered as transfer of obligations. Say for example, it may be with respect to payment to be made with respect to something, or a guarantee which is given, or it may be with respect to maybe the internal audit which was covered in a question a little while ago, where you take a certain amount from the other subsidiary to be paid to the holding company. Those would all be considered as transfer of obligations, transfer of resources, or transfer of services. Maybe you have certain number of people who are seconded to the other entity. What's interesting under LODR is LODR related party transactions, the way it is defined in LODR, would include cases even where no price is charged. So it's not only one where you charge some amount, even if you don't charge any amount, the provisions of related party transactions will still be required to be complied with. So that's what is important. Under LODR, although there were no specific questions on this, going by website disclosures as per regulation 46(1)(g), you're required to put up the policy on related party transactions on the website of the company. Omnibus approval is also provided, which is also there under 177 and of the Companies Act now.
Whether commission paid to whole-time director of a company who is also a director of board of directors of promoter group, company comes within the purview of RPT under section CA 2013 and LODR. Should RPT compliance need to be done for both the companies? Please, I think we have answered this particular question, because if it is part of the salary, then of course it will not be related party transaction.
See, when it comes to any remuneration, you need to see section 197 and schedule 5.
Yes.
If it is within that, there is no office or place of profit, it will not come under RPT.
Okay. If company is under construction, how to consider 10% criteria? Because it is say under construction, it cannot be booked in the turnover. So if I am dealing with the transaction, then 10% determination criteria will be tough. So what should be done in those cases?
So which company is dealing with this company? Is this the second company with which the listed company is dealing? Because this company certainly cannot be a listed company.
It can be, because it can be a listed company, because
so everything is under work in progress?
There may be under work in progress, like power companies. If it is a listed, Reliance Power, say for example, if it is going into the under construction and all construction contracts are there, and we are hiring services, so 10% criteria is required to be determined. I think project completion certificate from the engineer and all those kind of things.
In fact, what I would suggest is, in such a case, actually the provisions of LODR clearly provide that the board can finalize policy on material related party transactions. So, when they finalize the criteria for determining, these are the terms which have to be considered. How would income be recognized? What are the parameters that would be considered? Needs to be seen, and then you finalize it.
One more question, it is again
some
repeated.
More details will have to be gone into, which is the reason I am not going to elaborate it, as we are also running short of time.
Repeated again and again, in case or remuneration of related party is given on annual basis, every time we need to make the disclosure or not. So this question is a little bit big, but point is, if remuneration is given to related party on annual basis and there is an increment on regular basis, will increment will be considered as related party transaction or
no,
not?
So long as it is as per the remuneration policy, it is not something different. What needs to be considered is, if you are giving an increment, is it a contract or is it salary? I would once again go back to the provisions of Income Tax Act. If it is a contract, every time you increase it, please go to the audit committee and go to the board wherever necessary, depending on 188 and 15.2, 15.3 as the case may be. But if it is 115(3) limits in particular, but if it is one which is terms of employment, you don't have to go to the audit committee every year.
Whether shares covered under the sale or purchase of goods?
Yes, goods, shares are certainly
goods.
goods, so therefore shares would be covered. But this is a very interesting question, I would say. Let's assume there's a transaction of transfer of shares. Is it a related party transaction? If the transfer of shares is in dematerialized form, is it a related party transaction? My question here is, who are the two parties to the contract? Are the two parties to the contract the two individuals concerned or the company? If the company is not a party to the contract, it's not a related party transaction at all. So therefore, that is a moot question. Now coming back to the question of shares, if it's a transaction whereby the company enters into a transaction with a related party to buy shares or to sell shares, certainly it would be considered as purchase or sale of goods, falling under 188.
So that means buyback of the shares will be covered from the promoters.
Right.
Will be covered under the related party transaction?
If it is, that's a very interesting question that you've asked. Purchase of or buyback of shares from the promoters. In any case, you're going to take shareholders' approval. Of course, if it is exceeding the 10% limit. If it is not exceeding the 10% limit, you're anyways going to take board approval. And it's anyways permitted as per the provisions of Companies Act specifically, which is the reason the threshold becomes important. And you don't require the approval in such a scenario, provided you have complied with all other requirements.
Will transaction with holding company or fellow subsidiary company, which are foreign companies, considered as related party transaction?
As I mentioned, under the provisions of Companies Act, Section 2, subsection 76, subclause 8, until it is amended by the Companies Amendment Bill 2016, it refers to a company which is a subsidiary, and therefore foreign bodies corporate, foreign companies which are incorporated overseas, which are bodies corporate under the provisions of Companies Act 2013, will not be covered in my view, which is exactly the reason why it's proposed to be amended by the Companies Amendment Bill 2016.
Oh, yes. Other question, I think it has also been answered, but it is asked in a different way. If director is a common director in holding and subsidiary company and receives salary from both the companies, does it attract related party transaction?
The question is, if it's a director who's receiving salary from the second company, who are the two parties to the transaction needs to be seen. This is one which will fall under Schedule 5 Part 4, which requires disclosure, and it's one which only requires disclosures because it is permitted under Section 197. Just see Schedule 5, please. Any other company from which the person derives?
Schedule 5.
Schedule 5, yeah. Yeah, as per remuneration payable in two companies, Section 5 very clearly provides in Schedule 5, Section 5 provides that he may get remuneration provided it does not exceed the higher limit which is admissible, and also under Section 197 there is no bar on receiving remuneration.
From two dual employment cases. Yeah. Can a CS be appointed as CFO in a listed company? Will it? I think this question has already been answered in the first session.
Right.
While preparing for AOC2, reference of RPT as per I think this is also answered. Please explain Section 189 subsection 2 as it covers MBP 1 to be given by KMP and director at the time of their resignation as well. Please clarify.
I think this is a very interesting question. Now, at the time of resignation, the director concerned is not required to give his MBP2 to the company from which he is resigning.
Yes.
If he has resigned from some other company, there is a change in his disclosure which he is required to give. So, from the date of his resignation within 30 days, he is required to intimate the other companies where he is continuing as a director that he is resigned from so and so company, and therefore he ceased to have interest in those companies provided he is not a promoter or other provisions do not get attracted.
I think you have answered this question, but I am again repeating this question. if a director is holding share in a listed company, every time he sells shares and purchase shares, his disclosed stake in MBP 1 will get changed. So he has to give MBP 1 when his stake gets changed.
Actually, while there is a reference to shareholding, what needs to be seen is under section 2 subsection 76 as well as under section 184 subsection 2, you have a threshold of 2%. So therefore, any change in shareholding in couple of shares here and there, I would say need not necessarily be disclosed. So what needs to be done is, of course, it's for each individual company, have a threshold, don't have it absolutely at the neck of 2%, have a threshold which is slightly below so that you are in a position to bring it out under the radar. And in case of a listed company, you in any case will be going by regulation 29 of SAST with respect to changes. If you are a listed company, you will also have your PIT regulations where any change in shareholding in excess of 10 lakhs in value in a quarter will anyways get disclosed. So you would keep checking over there. If a related party, if a director holds shares in other companies, which where he keeps selling or buying, and every time there is a change in shareholding, are you required to monitor it? I would say go by the 2% threshold. So keep an internal threshold which is below 2%, so that is the way you need to monitor, not with respect to every treasury stock held by the persons.
One question, I think we have not covered this. 276(6) says any body corporate whose board is accustomed to act in accordance with advice on director. In case of common director in both companies, do we mean that board is accustomed to act accordingly? And if director is managing director in such a body corporate, will that be a related party? So I think accustomed to act concept should be.
See, accustomed to act, just because you have common directors does not mean that the first company is controlling the affairs of the second company, unless the actual facts are seen. So I think this question will require some more details to go into in terms of facts, but accustomed to act is little beyond that. Suppose, for example, you have let's say a joint venture agreement which says that all decisions of XYZ company will always prevail.
Always prevail.
Then in that case, will it be said that it is accustomed to act? Say yes, probably yes. I think one will have to go into some more facts.
I think you will have to go on the word accustomed itself, because it is coupled with the custom word, and it should be habit of that particular corporation to get the sanction from the parent company or say JV company to get the work done.
That's right. Ranjit, there's one point which I would like to specifically cover with respect to LODR. While under section 197 read with 178, if a director renders some professional services, he can be paid. It just requires a nomination. Oh, wonderful.
That was the next question.
Okay. The nomination and remuneration committee, if it approves, then there's no bar in paying. I mean, if the person is a professional, and you can definitely pay the additional amount, which will be quite okay, which is what Companies Act 2013 also provides. I would actually like to add that going by the provisions of LODR, it says that the
non-executive directors. Should I ask this question again?
Go ahead.
Another question. If two directors are there in a company and later their wife joined the company as an employee and a remuneration of 1 lakh each per month, so will the approval of shareholders will be required? 2,50,000 is the individual limit. If it is below 2,50,000 or if it is above 2,50,000, then approval of audit committee or board will be required or not?
Sure. The limit of 2,50,000 is per person.
Per person, yes.
So therefore, the two wives of the two directors would be treated as two individuals, and it will therefore be below the threshold given under 188. But it will require approval of the audit committee. It will also require approval of the board. It will not require approval of the shareholders.
Okay. Kindly define the explanation 1 of section 188. What is the meaning of over and above which he is entitled as director? Which
is under schedule 5 actually. Schedule 5 read with section 197. 197 read with schedule 5 to the Companies Act 2013.
So they are talking about what is over and above. So I think we can simply say that what is prescribed in your term and condition of the remuneration, that is your entitlement, and if you are getting even a single penny beyond that, that is over and above, and this
Correct.
thing has already been clarified at so many
Absolutely.
times. As per explanation, I think this is also the same question. One question which has came first, I am asking last.
Okay.
A Limited is a listed entity having associate company which is a private limited company. Enter into intercompany agreement with A Limited for availing services of employee, asset, computer, laptop for carrying business activity. A Limited into the business of special chemical business and its associate company into life sciences, healthcare and pigment businesses. Query 1. Is this a related party transaction? If yes, then what are the compliances for listed company and associate companies required? Is shareholders approval required? There are 5 company secretaries on the payroll of A Limited except 2. All other are CS of other associate company, and of 2 or which 2 are CS associate company. Is related party transaction? 4.
I
Is
think it's a very lengthy
very lengthy question. Is A
And,
Limited require cross
yeah.
charge associate companies?
Right.
Cross charge
Yeah.
associate company.
I think it's quite a lengthy question, and we really don't have much of time now. But maybe we could get a FAQ done of all the questions. There have been a lot of interesting
Because
questions
we are
that have
left
been
with
raised.
more than
Yeah.
hundreds of questions.
Yeah,
I think
and
we have already
I
answered
actually
them.
wanted to cover a lot more in terms of the legal provisions, but I think we are running
Short of
heavily
the
short
time,
of time. So I would like to close here, but it was really very interesting and enjoyable to answer and take on all these questions, and I hope the viewers found it really useful.
Friends, we have answered most of the questions. I think we have got more than 300 questions, and I can say that we are able to cover around 250 questions, but still there are say 20-25 questions left. So what I'll do, I will forward this question to Savitri madam, and just to prepare FAQ, all the questions will be in a say standard format, and we will compile all the things, and thereafter with the video link which we will be circulating, and mailer will be going for the next series, we will circulate this FAQ also, and which will answer all your question, because timeline I thought that 2 hours 30 minutes will be sufficient for related party transaction, because I have not kept any other topic except this. But I feel that there are a lot of concern and queries are there in the related party transaction. There are a lot of confusion between the provisions of LODR, provisions of section 188, schedule 5 and so forth. So we have, although we have tried to answer all the questions, tried to cover provisions including even registers of contract MBP1, MBP4, but still I feel that some of the queries are left unanswered. So we'll have the session maybe next later also on the related party transaction itself, but if we will be able to answer through FAQ, then I think that will also serve the purpose. Thank you very much for connecting with us again for the second technical session, and today also participation was huge. I was feeling that it's a long weekend and participation may be very low, but I think you have defied my logic, and definitely participation was very encouraging, and we will definitely come out with the next topic in the say next Friday or Saturday. So next topic will be announced through emailer. Web link of the first particular video recording, web link of the first first session, introductory session, is already available on YouTube, and it has been communicated to all the members through emailer, and it has also been communicated through the say invitation mail for this particular session. So if you are not getting the link, or if you are not able to view the video, kindly come back to us, and it is also hosted on the website of the company of the ICSI. So friends, thank you very much for coming here and attending this particular session, and request I think thank you very much madam for coming here all the way from Bombay and addressing such an important topic under the Companies Act, under the LODR, that is related party transaction. We have a small token from our side. Thank you very much for coming here, and thank you very much for addressing all the on the behalf of everyone. Thank you very much.
Thank you very much. It was really very enjoyable and interesting. Thank you, Sandra.
Thank you. Thank you.
Thank you.